Good evening to everybody here in India, and good morning to all in California. Maybe good afternoon in New York. And it's wonderful uh, that we are able to speak with you all. As you know, budget has been announced. It was anxiously awaited, and everybody had lots of expectations. Some of them have come true, some of them are expected, still left to the future. We got some guidance and direction, but what has actually materialized in the enactment is, I think, still a way to go. The entire thrust of this budget, there are two parts. One, there is more statement of intent. That's the first part. So, in terms of opening of FDI, in particular, for example, insurance sector has been opened up. Defense sector is being opened up to 49% by the foreigners or foreign companies. Of course, the fundamental premise being that the control of these entities will remain with Indians. So that's at least first major move. Almost for 10 or 12 years, I've been speaking in a number of different forums, that why not open up? If you opened up foreign investment in, say, insurance sector up to 26%, there is not much difference between 26% and 49%, because you already gave your negative veto rights to 26% owners. By not allowing investment to go up to 49%, all that you are doing is still giving negative veto right, but not allowing more foreign investment to come into India and making our insurance industry healthier. Same way in defense. So these are two sectors that are opened up, which gives some signal that India is now ready to think for more. And I hope that trend continues. Second thing that is very important to note is some change in attitude of India towards foreign kind of an investment. Traditionally, India only wanted equity investment, full risk capital, and foreign investment in equity was allowed originally only if somebody brought technology to India, and without technology foreign investment was permitted. Under the erstwhile FERA regulations, one could invest in India only up to 40%, even though he brought foreign investment. That changed in 1991. Foreign investment as an investment it was welcome, but debt was just not permissible. We had tremendous aversion to debt. That is changing. So now India is even encouraging debt. Concessional tax treatment is being given to debt. I would not go into the details right now. My colleagues Rajesh and Shreya will talk about these changes as we go along. But that is one interesting trend that has changed. Since about 2000, 2005, 6 onwards, attitude towards real estate began to change. But the conditions that were laid out for foreign investment in the real estate sector were also not pretty conducive. Now, there has been relaxation over a period of time, and now we are not only encouraging investment in the real estate sector, but also we have come up with what is called REITs regime and special treatment for REITs in India, real estate investment trusts. It is said that there will be a pass-through, but really speaking, it's a partial pass-through. Again, I would not go into the detail, but the concept is to most of the countries in the world provide full pass-through. whereas India has given only partial pass-through. We are going to be discussing structuring REITs day after tomorrow. Again, another webinar at 10 o'clock in the morning, and we'll be also streaming videos and stuff like that, so people who cannot attend at 10 o'clock maybe can watch through nishit.tv. We have our own TV and that will be streaming it. But so the attitude towards real estate has been changing. Another thing that has happened, India has realized that stability in laws and particularly in tax laws is very critical. As a result, there is a clear statement made in the budget that they will move towards more stable tax regime. India suffered a lot during last 3-4 years because of unstable tax regime, retrospective amendments, introduction of general anti-avoidance provisions, and even extraterritorial legislation. This budget has dealt with a bit with retrospective amendments, but they have not done what was widely expected by the global investors in particular. Everybody thought that government will withdraw retrospective legislation. Instead, government has said, no, Parliament has an absolute right to bring legislation with retrospective effect, but we will bring them, or will not usually do that except in rarest circumstances. Ironically, in some areas, in this budget itself, there have been some retrospective amendments. Again, I will not go into them right now. Shreya or Rajesh will deal with them, or Mahesh from Singapore has also joined this webinar. So, there is little disconnect the way in which this retrospective amendment has been dealt with. It makes investors little bit nervous, but it is positive tone is that the intent of the government is to bring stable tax regime. If some people have brought in some retrospective, maybe it was so consciously done or not by minister or at prime ministerial level, we do not know, but looks like that is something that they will correct. As I mentioned, one other concern remains is that there are lots of extraterritorial legislation. I think government at some point in time should also make a statement that we will not encroach on the taxing territory of other country, but that is next level. So it seems that on the whole, budget has provided good direction. It has provided some kind of comfort. More is expected because in about 45 days time, it's not always easy, and we expect that things will change with Mr. Narendra Modi becoming Prime Minister and having almost absolute majority in the Parliament. If this government cannot deliver, it is said that no other will deliver, because they can do whatever they want to, and then you cannot blame anybody else. Challenges are there, no doubt. How they will be dealt with, yet to be seen. Monsoon, it was eluding us, but now I think we are seeing some rains. Bombay is raining right now quite heavily. Delhi is very hot. So, we are still, but at least there is some relief that has happened. And other thing that has been done in the budget is the tax rates have been maintained at the same level. There has been some relief given to the lower middle class people in terms of the increase in the tax exemption limit. And as far as general anti-avoidance is concerned, it is not dealt with in this particular budget, and it is expected that something will happen. Government has already said there is some time by the time next budget comes, because GAR is going to be applied after 2015, and therefore after 2015 April. So government has already clarified that it is not that urgent as of today. We still have a few months to go, and within that we'll refine the whole thing. Maybe let us see in what form, what shape they make these changes. Another interesting provision that has been proposed in the budget is advance ruling for domestic investors as well, domestic taxpayers. Currently, we have a system of advance tax ruling, so you can go to the advance tax ruling authority and obtain a ruling on a transaction or a proposed transaction that you might have and get some kind of a certainty on the tax consequence. Unfortunately, the time limit that is prescribed by statute, which is 6 months, in practice it is taking almost 30 to 36 months today, and in number of cases advance rulings are being rejected simply because you have filed a tax return, okay, and which is a statutory obligation. So on the one hand, advance ruling applications not being disposed of on a timely basis, and taxpayers are required to file tax returns, and because that law requires. So there are some disconnect. At one point of time, the advance ruling process worked very efficiently in a timely fashion, but we are sure that this will be removed. But difficulty is that currently there has been little overload of applications. If they open up to the domestic taxpayers, the load will increase. But expectation is also that there will be a lot more benches of advance ruling authorities, because usually this authority is a very high level authority. It is presided over by the retired Supreme Court judge, and therefore people feel that you'll get good deal of balanced view of your tax affairs in advance, and therefore you can continue. So basically these are some of the changes that have come in, or the issues that have been addressed in the budget. And we I think at this point in time, all said and done, there is high degree of optimism, and we think things will be going for better. What I would like to do now is to have my colleague Rajesh Simon. He heads our international tax team along with me, and he will be moderating the webinar. Of course, I have already finished a lot, but I think now he's going to moderate me. So I am a moderate person now. So Rajesh, can I tell you? And the format we'll possibly follow is to speak a little and we discuss, so that it doesn't become so boring.
Sure. Thanks, Nishit. And yeah, as you mentioned, let's have a dialogue format, because I think that's probably the most useful way to sort of communicate the different viewpoints that are there. And I think the biggest thing I think that you started off in terms of, at least on the opening up on some of the sectoral restrictions on defense and insurance. Over the last couple of days, there have also been other relaxations that have come in from the Reserve Bank of India in terms of pricing regulations, which you always have the DCF as the pricing methodology in respect of transfers between residents and non-residents. We are seeing some relaxations in terms of any internationally accepted pricing methodology being allowed by the RBI. You're also seeing circulars or notifications that have come out over the course of today, allowing partly paid shares and warrants being issued to non-residents. So at least the trend that we are seeing is that foreign investment again seems to be welcomed into India. But having said that, again, in terms of the issues, some of which you raised, and also some which was when we start looking at the fine print of the finance bill, there are some 3 or 4 big changes which have really come through, and some which haven't really. Let me start off with the ones which haven't really come through, and the first one is the big elephant in the room. That's on the retrospective amendment which was brought about by Finance Bill 2012, which effectively taxed indirect transfers, so to say. That's the common parlance language that's used, where effectively, even if you have a foreign company that sold shares of a foreign company, but if the value of the foreign company has substantially derived its value from underlying Indian assets, then the transaction can still be brought to tax. This amendment was effectively brought about after the Vodafone judgment, and it was a retrospective amendment in the sense that it stretched back to 1961, the inception of the Income Tax Act in India. And at least this has posed a lot of challenges in the past few years for most M&A transactions that we are seeing at an offshore level. What the government has really stated is that as far as any existing transactions where there are litigations that are currently underway, it will proceed on to its logical end. As far as any transactions which have not been picked up till date for scrutiny by the income tax authorities, any such scrutiny will effectively be referred to a high level committee that is going to be appointed by the CBDT, which is the Central Board of Direct Taxes. Thirdly, what the finance minister has sort of indicated is that, well, we do have the right to bring about retrospective changes, but we'll be careful about its use and its application. So I think the biggest question that comes about is really what now? How do investors really approach future transactions as we move along? Considering that there's not really been any change as far as the retrospective amendments on indirect transfer are concerned, and also considering the fact that you do have a Shom committee report which had looked at some of these provisions and had suggested a lot of changes. None of it seems to have been considered by the finance ministry. So in terms of what happens to transactions going forward, how do people really look at negotiating or approaching such transactions? And I think the second biggest issue is what happens to the transactions which have been negotiated in the last 2 years. There are various indemnities and other negotiated arrangements that are there vis-a-vis the parties. So how do people really approach that? And let me start off with Shreya in terms of how do you really address both of these issues?
So I think, Rajesh, I'd like to take on the second question first, where we look at the transactions which have already been negotiated over the last 2 years. And there the issue really is that at the point when the law was introduced, it was introduced as a knee-jerk reaction to the Vodafone ruling. It wasn't thought through, the provisions were very widely worded. So if you look at the provisions today, they are capable of including within their ambit a large number of potentially incongruous situations. For example, if you have a US listed company and you have a US seller and a buyer selling a share, if that entity has a subsidiary in India contributing substantial value, this is still something that's potentially subject to the indirect transfer provisions. So evidently M&A activity over the last 2 years has been plagued by this. People don't know how to deal with it, and very often the question that we get is that this is a transaction that is entirely outside India, so why is Indian tax applying to this? Historically, the response that was applied is that parties try to deal with this risk contractually. So you would typically have a specific and very detailed tax indemnity. In some situations, if the buyer was more conservative, you would look at an escrow or a tax insurance. And somewhere the discussions were being driven by the expectation that there would be certainty introduced into the law at some point in time. Particularly after the Shom committee report came out, there was optimism that something would change. And I think that's really where some of the disappointment has come in, the fact that this potentially really big issue has not been dealt with. So probably, at least as far as the past deals are concerned, they have factored in this risk already, and they will go forward on the basis that nothing has changed on the indirect transfer tax front. And going forward also, we would expect to see the same kind of contractual risk sharing, tax insurance, escrow mechanisms and things like that, at least until there's some further certainty introduced into how these provisions can apply.
So Shreya, I think there are two other big issues that I see. One is the fact that the question of what tantamounts to substantial value. You've had one committee, that's a Shom committee, which talked about a 50% as a test. If the assets in India are more than 50% of the total assets, or the value of the Indian asset, of the Indian business is more than 50%, depending on what kind of business you are in. And then you also have a standing committee on finance which proposed a lower threshold. So the question is that when you're looking at deals, you have a 20% threshold which has been suggested by the standing committee. You have a 50% threshold which has been suggested by the Shum committee. You have a whole bunch of litigations before various high courts. So how do we really approach this now? Are we looking at 20%? Are we looking at 50%? What really, again, what do you look at when you're looking at substantial? And I think the second question is the use of treaties, because I think one of the things that I've seen quite a bit is that increasingly post the amendment, people have started trying to use treaty jurisdictions to structure around the indirect transfer, for the reason that under most treaties, when you're looking, or at least under a large number of treaties, there are situations where indirect transfer, the charge of tax is not really allocated to India, but allocated to the country of residence, and therefore you can sort of come out of the indirect transfer provisions. I think a bit on both of those issues in terms
Sure.
of how things will probably pan out.
Sure. So I think on the first question of what exactly substantial value is, uh, part of the movement around this has also been on the tax insurance front. Contractually, parties didn't know how to deal with the risk, so for a lot of M&A players, 50% was pretty bad, but 30% was also not a very good number. But when you look at the thresholds at which tax insurance has been given, until 6 or 7 months ago, insurers were comfortable at around a 30% figure, when 50% was the standard that was laid down by the law. But then, when the 20% standard came in as being a recommendation of substantial value, insurance has also dropped to that figure. So today, if you have anything that's over 15%, that would probably be considered substantial value, at least as far as your negotiations are concerned, or as far as tax insurance is concerned. I think on the treaty advantage, it is correct that people have started trying to see how treaties can mitigate this risk. But the real challenge there is that indirect transfer tax is a seller tax issue. So if you have a historical structure that you're carrying forward, and if that historical structure does not have a treaty weighing in, then restructuring may be expensive. It may not always be possible, and sometimes it just doesn't make a difference for a seller to put a new structure in place that involves a treaty, because the existing structure doesn't really allow it. So while treaties are definitely useful, they may not always come into play, but yes, we have seen a lot of people looking more seriously at jurisdictions like Mauritius, Singapore, Netherlands, which may have a capital gains benefit that can help mitigate this risk.
Sure. And speaking of treaties, actually, that's a good point, because that really leads on to the next topic, which is really on the general anti-avoidance rules. Because this was another expectation that was sort of floating around prior to the budget, as to whether or not the government would decide to push out the general anti-avoidance rules and have the effective date for it coming into place. Push it out to 2016 instead of it starting from 1st of April 2015. And the real question mark that is really there is that would these general anti-avoidance rules have an impact as far as treaty benefits are concerned? And speaking of the countries which you mentioned, whether it's Singapore, whether it's Mauritius or Netherlands, and I think Mahesh, I think now is a good time for you to also probably get you in terms of how do you really see the general anti-avoidance rules playing out vis-a-vis the treaty benefits that people ideally want to take benefit of?
That's correct, Rajesh. GAR will definitely impact all India-focused structures, and it will also impact Mauritius and Singapore, and which, as everyone may know, contributes almost 50 to 55% of foreign direct investment into India. Now, so since GAR overrides all tax treaties, it in a way adds an additional element of complication as part of the structuring, because today, if you see, the Singapore Treaty already has some sort of a substance requirement. Essentially, I mean, as long as the Singapore entity or fund incurs $200,000 expenditure in the last 2 years, it is deemed not to be a conduit or a shell company, right? And the Mauritius Treaty is also being currently renegotiated to incorporate some sort of substance threshold. Now, in addition to this, we will also have to grapple with GAR. Now, it's also important to note that although GAR is implemented only from April 1, 2015, and the budget does not defer it also applies to all investments and structures post August 2010. So if there is a structure that is being set up today, GAR will still apply as long as the exit of the transaction happens post April 1, 2015. Now, of course, the government did try to provide some sort of limited safe harbor, in the sense they have clarified that GAR should not apply to P-note holders or holders of offshore derivative instruments. But this safe harbor is limited, because the foreign institutional investor or the entity that is issuing the P-notes would still be subject to GAR when it is claiming relief under the treaty, whether it's Mauritius or Singapore or Netherlands or any other jurisdiction. So essentially, now with GAR around the corner, it is important that in all structures we clearly document the commercial justification for each step. And for example, there are several such justifications. If you look at investments from the US, now today, US and India do not have a bilateral investment protection agreement. However, if you make this investment from either Mauritius or Singapore, you are able to take advantage of a bilateral investment protection framework. Now this is a very important commercial reason, a non-tax reason for investing from either Mauritius or Singapore. And there are several other reasons. For example, you may have fund managers on the ground in Singapore or in Mauritius.
Sure. And I think one of the key points which you briefly touched upon was the fact that today you do have treaties which themselves have limitation of benefits. So the question that really arises is that if there are specific anti-abuse provisions which are actually set out under the tax treaties, Singapore already has them. Currently there's a negotiation that's happening with Mauritius, and the expectation is that that will also have a limitation of benefits article coming through. So the question that really that's open today is, if you have a limitation of benefit articles, or if you have a specific anti-abuse provision that's already incorporated in the treaty, can the general anti-abuse rules still sort of override that? Because that will probably be a key element on a going forward basis in terms of as far as foreign investment is concerned, considering that there is a substantial portion of the investments which are still coming through from either from Singapore or from Mauritius. And I think today that's a issue that's still open. While you do have the rules that are there and safe harbors that are there, but it still doesn't capture the wide gamut. The expectation currently is that we are probably going to come out, the government will hopefully come out with more detailed guidelines and hopefully set out circumstances when they will apply GAR and when they will not apply GAR. But as things stand today, we are looking at GAR coming into place next year. I think that the next key issue, and this is an issue which I think is going to impact a lot of people on the street, is in respect of the increase in holding period for determining long-term capital gains. Basically, as things stood earlier, in respect of any shares, whether it was listed equity shares or unlisted equity shares, if you held it for 12 months or more, then that would have been any gains would have been categorized as long-term capital gains. what the government had really done, and this was an introduction in the bill. There was not much mention of it in the speech of the finance minister. But what the bill has essentially provided for is that as far as listed securities are concerned, the holding period to determine whether it's long-term capital gains still continues to be 12 months. But as far as any unlisted securities, whether it is in respect of a public limited company or a private limited company, the holding period has effectively increased to 3 years for it to be treated as long-term capital gain. And Shreya, coming back to you, in terms of how do you see this actually playing out in terms of its impact on private equity players on going forward basis?
Yeah, so I think every year there are a couple of provisions that they sneak into the bill which end up being pretty important, and I think in this year's bill this would probably be one of the winners. And I think the real impact of this provision comes up from the massive difference in rates on capital gains from assets held for a long term versus short term. So if you're looking at a non-resident investor who holds unlisted shares, it's 20% on long-term capital gains and 40% on short-term capital gains. Now, if you're looking at a PE investor who's invested for a very long period of time, over 3 years, this may not make a substantial difference. But in some situations, you may have an exit and you may not have held on to the asset for that 3-year period, which means that your tax rate automatically doubles. Huge impact, right? What we need to keep in mind is that the exemption applicable to listed securities continues to apply. So if you're selling on the stock exchange, then if it's a long-term capital gain, you get the long-term rates even if you've held on only for 12 months, in which case the tax rate is 0. But for anything that isn't sold on the exchange, you have this 3-year period coming into play. So I think potentially a very major change. Whether the PE investor is impacted or not will depend on whether they've held on for 3 years or not. But yeah, potentially a huge deal.
Yeah, I think the only good bit is that most PE players have a 5 to 7 year horizon.
Yeah.
So at least while it may not necessarily impact a large majority of them, but obviously situations where let's say a late stage investor who's come in, or if there are strategic exit opportunities, those kind of situations can still be impacted. Of course, all of this depends on whether at least for offshore investors, whether the treaty benefits will actually hold good. Just going ahead, I think in terms of one of the changes, or one of the what I would call finality to a big dispute that always used to happen, was in respect of taxation of foreign institutional investors and foreign portfolio investors under the new regime that is there. Traditionally, there was always this issue that was there as to whether the income that is earned by a foreign institutional investor or a FPI, or foreign portfolio investor, was in the nature of capital gains or in the nature of business income. The reason why this was actually critical was that if it was in the nature of business income, there would not have been a tax consequence in India unless and until the FII or FPI actually had a permanent establishment in India. That's assuming that they were coming in through treaty jurisdiction. If it was in the nature of capital gains, they had to specifically rely on a treaty exemption, because absent a treaty exemption, any short-term capital gains would have been subject to a 15% tax. Of course, long-term would have continued to be exempt because of the levy of the securities transaction tax. And this matter had been litigated a number of times before the Advanced Ruling Authority. The Advanced Ruling Authority had taken conflicting positions in different cases. But what the finance minister has really stated is that any income that is earned by a foreign portfolio investor or a foreign institutional investor will be regarded as being capital gains in nature. And again, Shreya, in terms of the impact that this would probably have as far as FIIs or FPIs are concerned, especially considering that you also have a GAR provisions which are coming into effect at the backdrop, how do you see this really playing out?
Yeah, so I think this is again one of those bittersweet provisions, right? It's good to a certain extent the reason it's a positive kind of amendment is because this issue of whether FPI income should be business income or capital gains has been litigated so much. There's been so much uncertainty about where the characterization should lie. And Rajesh, if you recall, the revenue has historically taken the position that it should be capital gains, particularly in situations where the FII is situated in a jurisdiction like the US, which doesn't contain a capital gains benefit in the treaty. So I think the reason this was introduced is to resolve some of that back and forth, where they said this is the bright line test, FII income is going to be capital gains income. So to that extent it's positive. But where the issues really come up is, for example, if you look at derivative income of FIIs, if you look at Indian domestic tax law, derivative income has historically been characterized as business income. So now you have this anomalous situation where if you have an FII who has derivative income, it's capital gains. But if you have anyone else who has derivative income, it's business income, which is a little strange, right? The second issue that is going to come up is that FIIs, FPIs will now have a preference for jurisdictions which have beneficial capital gains provisions in their treaties, because this capital gains characterization has become clearer. So we'll see more of a preference for Mauritius, Singapore, Netherlands kinds of jurisdictions. But another curious aspect of the budget speech this time was that the finance minister said that they were looking at introducing a PE exemption for FPI fund managers situated in India. Now, the background to this is that a non-resident is taxed in India on business income if there's a permanent establishment in India. And under Indian treaties, there are some tests under which you can have a permanent establishment. One of the fact situations that creates exposure is if a fund manager is situated in India, then there is a possibility of risk. What the finance minister indicated in his speech is that he said that I want fund managers to be encouraged to come to India, which is why for FPIs we are going to introduce this exclusion. This did not form part of the bill, but there is some communication expected in this regard in the future. Now, the question this leaves open is that if there is a specific PE exclusion for FPIs and private equity funds were not specifically referred to in the budget speech, but on the other hand it was stated that FPIs can only have capital gains income, then what really is the benefit of this PE exclusion for FPIs? And the other issue that will come up is that FPIs tend to have automated trading platforms in India, which also create PE exposure, and that was not dealt with in the finance minister's speech at all. So I think it's a amendment that was motivated by good intentions, but how useful it will be in the long run is something that we need to see.
Speaking of the exclusion on the fund managers, because that was a nice statement which came out saying that, well, I want to ensure that I give an incentive for fund managers to actually locate themselves in India. And I think even in the memorandum to the finance bill, what the provisions really talked about was giving was to ensure that there is no permanent establishment for fund managers managing FPI. Mahesh, to you, in terms of today, what the provision seems to talk about is FPI, but not necessarily for private equity, and how does is there a possibility that this is going to be extended to private equity, and also how good how much of a benefit is it for them really?
Yeah, I agree with Shreya that this is a good effort, and it's great that the government has recognized this PE issue finally and has tried to provide some certainty. But the fact that it is limited to FPI, that is the foreign institutional investors or the portfolio investors, that sort of creates some issue, because the PE issue equally applies to private equity funds, and it becomes an issue when you have the investment advisor in India, when you have fund managers on the ground in India, right? But even if the government does extend it to private equity funds, it does not answer all the issues, because there is a logic behind providing incentive to having the fund manager located in India. But at the same time, you need to have fund managers on the ground in Mauritius or in Singapore because you need to justify substance, and that's how. And this becomes even more important when GAR comes into force. So I guess this clarification may not really have the kind of positive impact that was hoped.
Sure, and hopefully, let's say they will resolve some of these issues by getting in circulars, but that's again still something that we have to just wait and look
language
forward.
of the circular, that's correct.
Yeah. Just moving to the next set of what I would call key amendments, looking at resolving some of the pending litigations. And again, one of the things, the challenges which people have faced in India over the last 5 years is the quantum of litigation. And when I talk about litigation, there are two sets of litigation. One is anything relating to any international tax issue, or I think pretty much every single MNC in the country is saddled with some kind of tax litigation or the other. And the second is in relation to transfer pricing litigation, where again, I think just last year or the year before that, the adjustment in one particular year was more than $10 billion. And currently, as things stand, more than 70% of the transfer pricing litigation in the whole world is concentrated in India. So that way we've been pretty prolific on that. But the budget did introduce two sets of changes, which I would tend to think is a big positive. Nishit did mention about one of them when he talked about the fact that what the finance minister has indicated is extending or having more benches of the advanced ruling authority to sort of take care of, at least to fast track some of the disputes that are there. The advanced ruling authority was supposed to deliver judgments within a 6-month time period. Last 5 years that hasn't happened. We've had advanced rulings which have stretched on for 2 to 3 years, if not more. And obviously there is also a issue relating to the quality of judgments that had come out over the last few years. But at least the positive intent that we have seen from the finance minister is the fact that extending the advanced ruling mechanism to residents, and having more benches in place, which will hopefully take care of the backlog of litigations. The second set of changes on the litigation front is really extending the advanced pricing arrangement mechanism. And earlier you had the earlier finance minister had introduced the advanced pricing arrangement, at least to try and see to how best to mitigate transfer pricing litigations by saying that, well, you can go in and enter into APA which will be valid for 5-year period. What has happened in this particular budget is we have a situation where, in addition to extending the APA for a 5-year period on a forward-looking basis, but to also extend it backwards for a period of 4 years. So, which would mean that today, if I want to go in and enter into an advanced pricing arrangement, it can even cover the previous 4 years and also the future 5 years. So, you now have a 9-year period where you have effectively got some degree of certainty in terms of fixing your markup and fixing your margins. And Shreya, in terms of how do you look at it in just looking at the sheer quantum of litigation that is there, and also at a practical level in terms of how the APA mechanism is actually working?
I think this is one of the most positive changes that the budget has sought to introduce. Also because, when we say that there's 70% of the world's transfer pricing litigation is from India, it's also helpful sometimes to go back to why this ended up being the case. The revenue authorities did have unreasonable targets to meet up with, and transfer pricing at the end of the day is a very subjective area of law. So it's much easier to initiate assessments in relation to transfer pricing in comparison to other tax provisions possibly. So I think the finance ministry has been cognizant of this. If you recall, last year they introduced safe harbors, for example, where they tried to divide up the industries and say that for these industries, these are the transfer pricing margins that we're looking at, which was a very positive measure. And this year, again, with the APA rollback for 4 years again a very positive measure where they're saying we realize there's an issue and this is how we want to administratively try and resolve it. I think the other two positive changes they introduced this year is that they've allowed for multiple year data to be taken. So in a situation where you don't have adequate comparables in a year, for example, or where 1 year is not representative of your real business, you do have the flexibility to take on multiple years of data. And the other amendment is that they've started allowing for an interquartile range of arm's length prices instead of the arithmetic mean which was previously followed. And the interquartile range is basically what the OECD follows, and there's been discussion about it for several years, but this year we've finally seen it coming through. And I think at least when litigations are initiated, the fact that there is official communication like this from the top and administrative measures such as more APA benches, that's really going to help out things on ground.
Sure. Yeah, you're right. As in, hopefully, at least on a going forward basis, there would be a reduction on the transfer pricing litigation at least. I think more than anything else, I think Indian tax authorities have been extremely aggressive as far as transfer pricing litigation is concerned. So if you do have a good APA mechanism that actually functions properly, this I would look at it as a definite positive. The next one is really, the next change is really on the introduction of the REIT regime. Again, we are having a webinar on this day after tomorrow, that's Thursday at around 10 a.m., where we will be discussing the whole details relating to how do you really structure a REIT and what would be the complete tax consequences. But I think this is a good time to actually touch upon in terms of how the whole backdrop of the REIT and what the finance minister has suggested as far as the tax proposals relating to REITs are concerned. So you had, at least over the last couple of years, there's been a lot of discussion as to whether India is ready for a REIT regime. SEBI, that's the Securities Exchange Board of India, had come up with draft regulations relating to REIT in December of last year. And the expectation was that it would probably come into place by end of last year. But the matter got stuck because the tax proposals as to how a REIT would actually be taxed there was no mechanism that was there in place. There's been a lot of back and forth between the advisors and the regulators and with the finance ministry, and there's been a lot of industry representation. So we finally see in terms of how the tax consequences as far as a REITs would go. And as Nishit mentioned, the ideal world was really a complete pass-through, which is what is there in a lot of other countries. But that is not what you have in the proposals which have come out. What you really have is what I would call as a partial pass-through, where at least for interest coupons which are being paid out by a REIT, there is a pass-through that is there, so that there is only one layer of tax in the hands of the unit holders of the REIT. So when you look at a classical REIT regime, you're looking at 4 different players. You have a sponsor of the REIT, who's really the person who's folding the assets into the REIT. You have a SPV which is held by the REIT, and the SPV actually holds the asset. The SPV may be paying out dividends or interest to the REIT, and there may be situations where the REIT would be disposing of the shares of the SPV and generate capital gains. And you have the unit holders who are really the unit holders of the REIT. So in the first place, when the sponsor really transfers the shares of the SPV to the REIT, the regulations as they the proposals as they stand provide for an exemption on the transfer of the shares of the SPV to the REIT, so long as you get units in return, units of the REIT in return. The second part of the transaction is where the SPV actually pays out interest coupon to the REIT, which is then paid out to the unit holders. As far as this stream of payment is concerned, there is a pass-through mechanism that is available. There is no tax that's going to be levied in the hands of the REIT. There is a withholding tax which the REIT has to undertake. There's a 5% withholding tax as far as payment to non-residents are concerned, and there's a 10% withholding tax as far as payments to residents are concerned. The 5% withholding tax to non-residents are effectively the final tax liability as far as the non-resident is concerned. This sort of puts it on par with some of the other interest instruments, for example, foreign currency borrowings or infrastructure bonds, which also enjoy the 5% regime. So you effectively now move to a 5% tax as far as any interest payouts are concerned. As far as any dividends which are being paid out by the SPV to the REIT and passed on to the unit holders, there is a tax that's going to be levied in the hands of the SPV, which is the normal dividend distribution tax that is there. There is not going to be any tax in the hands of the REIT, and there is not going to be any tax in the hands of the unit holders. The third stream of income which can arise is capital gains, which is when the REIT effectively sells off the shares of the SPV to a third party buyer, in which case there is a tax that's going to be levied in the hands of the REIT, which can be either short term or long term at applicable rates, 20% or a 30% rate. There is not going to be any tax in the hands of the unit holders at the time of distribution. The last stream of income which a REIT can really enjoy is if it's getting some management fees or if it's getting certain other types of lease rentals. This can be in situations where the REIT is directly holding the assets instead of holding it through a SPV. In those situations, there would be a charge of tax in the hands of the REIT at a maximum marginal rate, which is a 30% rate, and no tax in respect of any distributions which happen to the unit holders. The unit holders, since the REITs are going to be listed, the unit holders, when they transfer the shares of the REIT, if it's long-term capital gains, no tax. Short-term capital gains, you will continue to pay tax, similar to most other instruments. The exception here is that if a sponsor who has received units of a REIT, if he's going to be selling shares, he is not going to enjoy the tax exemptions which may potentially apply to a unit holder. So therefore, to that extent, I look at the whole structure as a sort of mixed structure between a classical pass-through and a no pass-through. And Mahesh, I think the question to you really is, and you've been in Singapore, you've seen the way Singapore has been looking at REIT structures. How do you sort of see the difference or the distinction between probably how Singapore looks at taxing the REIT regime and the proposals by the finance minister?
Sure. I think Singapore has probably one of the largest and most successful REIT regimes and REIT markets in Asia, and they've done a great job here. It's mostly pass through, and even for rental yields and management fee. Of course, Singapore does not have any capital gains tax. I think one issue could be the cap. If the gains from sale of property is treated as business profits, then it could be taxed at the level of REIT. But otherwise, it's mostly pass through. But I guess investors are quite happy with what the government has tried to attempt. Yes, it is a partial pass through, but a REIT regime as such has been long overdue, especially if you look at the size of India's market. And I'm quite sure that there are representations being made, and I'm quite sure that these provisions will be improved upon. That once they're finally enacted, and also over the years, I'm sure the government will take care of these issues. And of course, on a slightly different note, I also hope that the government will announce the pass-through status for all categories of onshore funds or alternate investment funds, because that also has been a long-standing demand of the industry. It seems that this government is quite committed to working with investors, ensuring certainty, and I'm sure that all these proposals will see the light of day.
Sure. I think the one other point which really, when we're talking about REITs, which I should actually include, is that there was a lot of discussion as to what should be the extent of the REIT regime, whether a similar mechanism should be put in place for infrastructure investments. You have examples of public examples where Indian companies have gone to Singapore and raised business trusts for investments into Indian infrastructure. So the question that was always there was that should you have a similar regime and have infrastructure investment trust also in India? SEBI was initially coming out saying that, well, we want to restrict it to only REITs, not for infrastructure investment. The good thing here is that what the finance minister has really done is, if you look at the budget, it's not really the tax treatment that is being described is not only for REITs but also for infrastructure investment trusts. So obviously now the expectation is that you're going to have a similar regime even for infrastructure investments, which can be sort of bundled into a trust and be listed on the Indian Stock Exchange. Really good from a capital markets perspective in India. Additionally, there are also other relaxations which have come through. One was really in terms of extension of the lower withholding tax of 5%, which was there for foreign currency borrowings and infrastructure bonds, which was lapsing next year. The government has extended it by a year. Similarly, what the government has also done is that earlier foreign dividends that were received by an Indian company were subject to a lower rate of 15% tax, and this sort of lapsed as of 31st March 2014. The government has extended this in perpetuity. So therefore, there are other relaxations also which have sort of come through during the budget. There have been other things like additional investment allowance that's being given. There are benefits that are given at a personal taxation level. The focus around it has been mostly that we want money to be put towards building capital assets, or towards building of or towards making investments into the country. I think that's been the whole thrust of it. I think obviously the way I would see it is that it's a good start after I think a last 3 to 4 years where there's been a lot of issues which have plagued foreign investors. I think this budget has really been at least a good start. I wouldn't say it's a perfect budget, but Nishit, for your final thoughts before we open it up to the audience.
No, I think all of you summarized most of the provisions of the finance bill, and also the steps that are proposed to be taken. Intention of the government is very clear, to attract more investment and more foreign investment. And the way in which I look at, in 45 days time you cannot expect too much. Even to think of all these issues itself and making a decision, it was not possibly an easy task. So from that perspective, we must compliment this government. And obviously things will never be perfect as you want. I hope the government still addresses retrospective amendment, which really puts little brake on the investors, because investment is a matter of confidence ultimately, and anything that deters that confidence, I think one has to be careful, and people would take a little view about how it's going to unfold. Number two, that general anti-avoidance is still an issue, and that is what is carrying everybody. Some people tell it's a tool of fiscal terrorism and lighter vein, and that became all over the newspapers all the time. I think those comments are really causing some concern, and we should get anything that comes in the way of investment. Let us focus on one single objective, and that's we want investment, and investment at the speed of thought. Okay, if we do not do that, I think you do not know where things can slip out in between. We think in 6 months, 12 months, but today everything is moving so fast that if you do not take necessary steps on a timely basis, I think and some people say it will take 5 years, 10 years, but in internet world 3 months makes 1 year. So every time you delay anything by 3 months and compare it with historical developments, 3 months is almost as good as delaying by a year. So 1 year makes about 4 months. Anyway, So I think speed is the essence, and I'm sure that if people give right input and feedback to government, at least this government it is expected to listen. And if, as I mentioned in the beginning, that they have a full majority, okay, so they can do anything. So if they do not do it, then possibly they will have some difficulty. So I think those are the kind of things. What I would like to do is to open up to questions, but before that, two things. On Thursday morning at 10 o'clock Mumbai time, there is going to be a kind of round table and the webinar on structuring REITs, because REIT is a very complex subject, and I think we needed a special meeting for that. So we are going to have a small round table, and we'll open up over the audio as well. And the second event we are having is in New York, in PRA Hotel, Taj Group Hotel, on life cycle of fund, India focus funds, and that is half-day program beginning at 1:30 on 22nd of July, that is Tuesday, and going in until the evening. And you can always look at our website, or if anybody is interested, please send an RSVP at nishitdesai.com. We'll be happy to give you information. But that's a very interesting program. Overwhelming response we have, and we had a smaller room. Now we have over 130 people coming, all the top fund managers and other people. So if any of you are interested, please look at it, and we'll be happy to get you involved. There is no registration fee, so there is no free lunch, but we'll also give you lunch, no problem. So most welcome. That's on Tuesday, 22nd July. With those words, let me open up to the question answers, and let's move on.
Thank you. Ladies and gentlemen, we will now begin the question and answer session. Anyone who wishes to ask a question may press star and 1 on your touchtone telephone. Participants are requested to use only handset while asking a question. Anyone who has a question may press star and 1. To ask a question, please press star and 1 now.
I think we can close.
Yeah.
So I think our presentation it was very clear. There were no questions. We had some in the morning, and I think we've been talking about it. So I think it was useful, and we really appreciate all of you coming here and coming on the audio. And with that, I call this meeting to a close, and thank you so much.